My microphone, and thank you everyone for being here.
Well, good morning everybody from Berlin to the very first session of this year's IGF, and it's the classical thing in the early morning and in the first session that we all have to deal with some technical problems, but relative to this, I think we managed quite well. Again, a very good morning, and this is a global panel, so wishing you all a good morning. This is very much the Berlin perspective. We have panelists here from Asia, from the US, and from Latin America, and I'm very pleased to have you all here in our panel. A very warm welcome on behalf of the organizers, on behalf of Konrad Adenauer Stiftung. The fact that we have such a globalized panel actually reflects two things. Number one, the global character of Konrad Adenauer Foundation, of Konrad Adenauer Stiftung as a global institution, and of course, secondly, the nature of the topic, data governance in a worldwide perspective. It reflects our work as an institution that is active worldwide in promoting rule of law, liberal democracy, and data governance is a very important part of this, and it became a very important part of our work. Most of the experts we have here on our panel this morning are part of our worldwide network of the networks of our field offices around the world. And of course, with Mr. Voss, we have one of the most prominent data politicians in Europe among us this morning. It's very warm welcome. Konrad Adenauer Stiftung was involved in the first time in an IGF last year when it took place, and we had a lot of activities in last year's IGF, and I'm very pleased that this time in the virtual IGF we can also organize this panel. This year, we want to focus on global data governance issues. A few weeks ago, we organized the European Data Summit in Berlin, probably one of the most important meetings where stakeholders, experts from all over Europe could meet and discuss data policy issues. So it's kind of a logical consequence also to be present at the IGF this time. And the urgency of that issue is not only underlined by the scandals and some dynamics during the last years, but it's also underlined by the many policy efforts that are currently going on and that we are going to discuss this morning. With this background, many thanks to everybody for joining us so early in Europe, in the afternoon in Asia, during the night in the US. Many thanks to Sebastian Weise, who organizes this panels. Thanks in advance. And special thanks goes to my friend and colleague Eduardo Magrani. He used to be CAS fellow the last year, and he is going to introduce the panelists and to moderate the panel. So I'm pleased to be able to hand over the floor to Eduardo.
Perfect. Thank you very, very much for the introduction. Let me briefly present myself and the speakers. I'm Eduardo Magrani, a former CAS fellow. I'm also the president of the National Institute for Data Protection in Brazil. I'm postdoc here at the TUM, the Technical University of Munich, and also affiliate at the Berkman Klein Center in Harvard. So introducing our panels, we have here Natalie Pang, senior lecturer and principal investigator at National University of Singapore and head of the Global Citizens Dialogue, We Are the Internet. Fiona Alexander, policy strategist in the School of International Service America University and former associate administrator for the US Department of Commerce, National Telecommunications and Information Administrations. We have also Axel Voss of CDU, member of the Committee on Civil Liberties, Justice and Home Affairs, in the Special Committee on Artificial Intelligence and the Digital Age. Cláudio Lucena, I think he's just trying to come in here, a professor at the Law Faculty at Paraíba State University in Brazil and researcher for the Portuguese government agency Fundação para a Ciência e a Tecnologia. So just reinforcing, thank you very, very much once again. It's really, really early for many of you. So thank you for joining our panel. Just as a brief introduction about the topic itself, we are already living in a data-driven world that needs to have this important data governance. We are perceiving different data governance frameworks coming from a variety of countries and also regions worldwide. We all know very well the importance of regional frameworks like the Gdpr, for instance, coming from Europe, which got viral in many other regions. So for instance, in Latin America, we had frameworks that were very much inspired by the European regulation data protection, such as the Brazilian data protection regulation. But we also have some cultural and international clash between some of the frameworks. So Europe prefers a kind of more robust data framework. The US prefers somehow self-regulation, at least in the federal level, although we have some very interesting bills coming from California and some other states as robust also legal frameworks for data protection. Claudio is there right now. Morning, Claudio. And we need to balance in which way robust frameworks like the GDPR are more interesting than other formats, balancing robust regulation. Hey, Claudio, we can see you. With innovation and with economical development, for instance. And besides, we have those different data protection frameworks worldwide. It's worth discussing what happens on international data flow. We had interesting decisions concerning the privacy shield, for instance, between the US and Europe in a very recent Schrems II decision from the European Court. And that needs to be addressed as well for us to have a trustworthy process of international data transfer. So would be an interesting way to go, considering international data flow or international data transfer, to build global frameworks for data protection, or we are better just with those silos regulating regionally data protection. So the idea of this panel is accomplishing an interesting discussion also among different regions. So each speaker will bring up their own inputs about this, bringing their considerations about what is going on in terms of data framework in each region, and also bringing their inputs about this necessity or not for us to have a global framework and what are the benefits and challenges of that. So saying this, thank you very much. And I will immediately pass the word to Natalie Pank for us to start with. So Natalie, warm welcome for you. I would let you give your initial statement, give you some room for you to bring up your considerations about the description I just mentioned. And just as an initial provocation, maybe already addressing one targeted question that will be, in Asia, we have a good variety of data frameworks. The regions are very much diverse. So the first targeted question I would like to address you is, how do you perceive this variety of frameworks and culture, and how do you balance those benefits and risks of international data flows in the Asian region? Be very welcome, please.
Thank you, Eduardo. I hope everyone can hear me okay. Hi, everyone. I'm Natalie Pang. I work at the National University of Singapore. I will speak to this topic for a couple of minutes based on my ongoing project on data and innovation in Asia. So it examines data governance and innovations in 7 Asian countries, including Singapore, India, South Korea, Japan, China, Hong Kong, and Taiwan. So in each country, we examine policies and legislations associated with personal data governance, as well as perceptions of what these different policies might mean for different domains and industries, such as transport, health, e-government, fintech, and retail and industry. So the project is actually, the fieldwork is actually still going on right now. What I say right now is not the final conclusions of every the perspectives from every country. But what I can say is that legislations in like what you rightfully pointed out, it's actually the data governance frameworks, they are quite diverse, and different countries in Asia, we have different states or different levels of development or developing legislations to protect personal data. I would also say that challenges are quite different in different countries. So in Singapore, the issue of trust, the citizens' trust in not just who manages the personal data, but also the safety and security of that personal data is quite salient. And when it comes to, for instance, a country like India, the issue of data localization is really, something that's quite an ongoing debate, right? It refers to the extent to which we place restrictions on the transfer of data outside the country. And in Taiwan, the engagement and debates around personal data and governance centers very much on citizen democratization and as well as engagement. What I would also say, just in general, before I answer your question, is that a lot of these discussions about legislations and legal provisions to protect data, I think it has to, for me, it has to be situated in the socio-political context. Now, what I mean, what I think about this point is that the perceived relationship that citizens perceive with their how their data is managed, right, is very much mediated by their relationships with the institutions and organizations that collect their data. So with in a high trust environment, there tend to be greater trust placed on, all the policies and governance of the data. There are nuances as well, right? When we look at within each country, that this kind of trust as playing out between the citizen and governments and citizens and organizations like Facebook and so on. I would also think that say that one thing that's really interesting to me is this emerging theme on sovereignty and the role of nation states in the future of data governance. As I guess for me, looking at Asia as a region, the question is to what extent can we imagine or reimagine this sovereignty or this consortium that looks at the development of data governance? Can we go beyond nation states, perhaps to also include civil society actors and civil organizations, for instance? So you asked the question on the diversity of data protection frameworks and how do I look at the differences. I think for me, just a couple of things. I think in some Asian countries where we have regulations of data protection, for instance, in Singapore, we have actually a broader leeway in terms of data collection, use, and disclosure of data. So, so government agencies are also not governed under the same framework. This framework is actually just for private companies and individuals that are collecting data. The other thing that I think that is a bit different is that which also has an impact in terms of how this issue is developing in Asia, is this, I guess, consent-oriented nature of data governance and collection. So, so we do hear from the ground, based on interviews with experts and stakeholders, that they perceive this consent-oriented culture that's coming from GDPR, right? That from the EU, and there are questions about whether or not these consent-driven requirements may be relevant domestically or not. And I think I spoke about trust earlier, and this has also implications in terms of how there are provisions for companies and institutions to collect data. And one of the things that I think that is different from the guidelines in GDPR has to do with data minimization obligations that are very much enshrined in the European Union's GDPR. So in contrast, we have, for instance, in Singapore, we have actually companies that usually collect as much data as possible, and only later they decide how it should be analyzed. So based off our interviews with representatives from these companies, they would even suggest that actually they might not know the value of the data at the point of collection. It is something about that actually the value is something that is kind of thought about later. So this is actually another point, I guess, divergence from the data minimization clause. I think, the last but not least, I think the other divergence has to do with data transfers and localization versus the ability to aggregate and analyze data from different countries. So in Asia, we don't really have actually a new universal framework to do that. But it is something that is thought to be actually advantageous, especially for the development of innovations.
Perfect, Natalie. Thank you so much. I'll pass the word now to Fiona Alexander. So Fiona, we are facing the US elections right now. So one thing that I would like to know is how do you perceive the lessons learned from the US, considering the Schrems 2 case, for example? How do you think the elections in the US will impact data governance as well? And if you could bring up your own initial statements of pressing issues for you, things that you consider very important as well. So please be very welcome.
Thank you, Eduardo, and good morning, good afternoon, good evening to all. It is very early here in Washington, D.C. My puppy dog is very confused as to why we're awake at 1 a.m., but he's back asleep, so it's good. So thank you again, and I'm very pleased to be joining this panel of great experts. I'm probably the least of all the experts on privacy, but I'm happy to kind of give the perspective here from Washington, D.C. On some of this and happy part of the conversation. So maybe just to start off with sort of the thinking, and I think this is said often here in the United States, which is there are privacy rules here, and people take great pride in pointing to the Fourth Amendment to the Bill of Rights from 1789, which actually has a reference to and is about unreasonable search and seizure. So we do have a history of privacy here in the United States, unlike other places in the world. And Mr. Voss, who's an expert obviously in GDPR, and will speak to Europe. Here, it's historically been very sector specific, and context is key here in the United States. I worked at NTIA for about 20 years and covered 4 different administrations, so kind of a broad range of perspectives on the different things that we tried to do over the years on privacy. And one thing that I wanted to make sure I at least talked about was what happened during the Obama administration. At the time at the Department of Commerce, we ran a series of public consultations and met with stakeholders and issued a green paper, which ultimately culminated in a white paper in 2012. And that white paper in 2012 actually laid out a pretty broad privacy framework that the administration at that time was proposing. It included the idea of legislating a consumer privacy bill of rights. And that privacy bill of rights was very simple, 1 sentence, 10 sentence declarative sentiments. It was very important at the time. I think my boss really wanted to make sure that the consumer in the United States actually understood what was happening. And that was the idea of having a consumer privacy bill of rights and calling on for Congress to legislate that. It also called for NTIA to run these multi-stakeholder processes that would flesh out the specifics of the Bill of Rights. It could happen issue by issue as stakeholders wanted to allow for the flexibility. The idea too was at the time those could become binding corporate rules if it made sense. Those multi-stakeholder codes of conduct would then be enforced by the Federal Trade Commission. So there was your enforcement possibility. The challenge that the administration ran into at the time was in 2012, there was very little appetite in the United States for legislation in Congress and very little support from US stakeholders, including industry, for legislation. So fast forward 8 years and what's happened here in the United States. In this administration, NTIA issued a request for comment in 2018 with the idea of establishing clear principles that would guide the administration's interaction with Congress. The idea was that you would try to advance consumer privacy while protecting prosperity and innovation. Those public comments are on the website. The administration never issued principles as far as I'm aware. At the same time, NIST, which is a sister agency at the Department of Commerce, started a voluntary risk-based approach framework. So those are the two packages. Over half a dozen bills have been introduced into this current session of Congress to kind of deal with the issue of having a comprehensive privacy approach in the United States. There are 3 broad similarities in the sort of half a dozen bills that are currently under consideration. 1, they recognize individuals' rights to control their personal information. 2, they require a defined class of entities to take steps to respect those rights. And 3, they create procedures to enforce those requirements. That said, these bills have very big differences when it comes to the following 3 things. And these are issues that are sort of stumbling blocks right now, I would say, in coming up with legislation in the United States. 1, which federal agency actually would enforce these laws, whether to preempt state privacy laws, and whether to provide a private right of action. So from 2012 to 2020, what's changed and why are people here in Washington now calling for more of a comprehensive approach to privacy? Well, GDPR, which we'll hear about later on, I'm sure, has definitely impacted the conversation here in the United States. And probably even more directly is that the variety of states around the country that are actually passing or considering state level laws, which leads to confusion, concern, and some kind of issues about cross-border data flows, even within our own country. Obviously, California, being the most prominent, has a version of GDPR they've passed in 2018. And we have 19 other states here considering legislation or having task forces to look into it. So what's next and what's coming? As Eduardo mentioned, our election is tomorrow. Actually, it already started because everyone's been doing early voting, but tomorrow is the end of the election day. So we'll see tomorrow or this week what happens with the election and where things go with potentially a new administration or a second Trump term. And then the question is, what's the impact on Congress as well? It's hard to know until you actually see what the results of the election are. And then even then, I think if you try to predict what's going to happen here in Congress, you would always be in a losing proposition. You never know what's going to happen with the dynamics. But there is some sense of perspective. In the Democratic Party platform, there's a promise to update the Obama administration's Consumer Privacy Bill of Rights, and along with strong national standards to protect consumers, employees, patients, and students from data breaches. The Republican Party has, in their platform, focused on discussing the harms of encryption. So you see a little bit of a different philosophy in terms of where the focus is. But again, with the 6 bills that are pending in the current Congress, proposed by Democrats and Republicans, and in some places bipartisan, you still have these three big differences about which agency is enforcing, whether to preempt state privacy laws, and whether to provide a private right of action. And I think that the action here in DC is going to be around those three things once a new Congress is sworn in. I'll also make sure that folks understand that when there's a new administration that comes in January 20th, the new Congress starts, I think, January 3rd or 4th. And with the new cycle of Congress, all the bills that are pending that don't get approved basically go away, and everything has to be reintroduced. The one thing I am positive of is that in the coming year and in the January-February cycle, there will be a conversation about privacy and where we go from there. So just leave it at that.
Perfect. Thank you very much for your input. Now I want to pass the word to Axel Voss. Axel, Natalie talked a lot about the influence of the GDPR in Europe. So as an initial statement, I would like you to address the importance of the GDPR so far, considering that we just faced the 2nd anniversary of the GDPR. So I think it's the right timing to balance the benefits or not that it's being given. So how do you perceive this balance? Is being important for innovation development, to guarantee citizens' rights in terms of privacy and data protection? The European Commission already published a statement about the 2nd anniversary of the GDPR, but I want to have your opinion on that. How do you balance the efficiency of the GDPR so far and the benefits of it, just as initial statements so far?
So good morning here from Europe to everyone, and thanks a lot for the invitation. So coming to the GDPR regulation. So the GDPR is a key element for the European digital single market, or the single market itself. Key element because it should build trust for the consumer, for the individuals to use the internet, and having in mind that there are some rules in place, and the companies who are collecting a lot of data have to orientate themselves along these lines, and this is more value orientated. And it should build this trust, and is also kind of a key element and one step to this digital sovereignty for our citizens, and also digital sovereignty, at least then also for the European Union at the end. So we have a lot of rights included, a lot of proceedings included. And so this should be something where I would say the whole environment is somehow regarded. And so that's why I think, together with the interpretation of our fundamental right of data protection, so what the German Constitutional Court was once saying, the informational self-determination, and this is combined to something where I would say this is a very good starting point. And although I have a lot of criticism also regarding the content of the GDPR, but don't get me wrong, the GDPR is a kind of a cornerstone, and I still would say it's necessary to have. And so if we would like to deal value-orientated, then we should have something like this in place. But from my point of view, it could have been done better. Even if you think, oh, it's already very complicated and so on, but it is also, it could have been done better. Not only simplifying a little bit, sometimes it's probably too detailed, And again, sometimes the European Union is exaggerating the data privacy or protecting privacy in a way, because we are thinking about an addition to the GDPR regarding the so-called e-privacy directive, probably in the future also a regulation. But then it's getting, again, complicated. So if we then have two consents and informed consents, and probably not meaning the same sometimes, or if we look into the situation, if you are storing data, this will underfall the GDPR, and e-privacy would mean the transferring of data to another point, and this might all get probably too complicated, and that's why I'm always trying to argue that we should do this more in a simple way and all together, and have one legal base and not a lot of them, not splitting everything and so on. But as what Natalie and Fiona already also mentioned, so coming back to the principles, what we have included in the GDPR. So as mentioned already, data minimization, or the purpose orientation, or the deletion of not necessary any longer data, and so on. And here I have to ask myself, or we have to ask ourselves, is this already the right approach for the future? So these principles are coming from the 80s of the last century. And so I'm asking myself, now we are facing a totally different situation. And are these principles still valid, or shouldn't we have adapted them more to the current situation? So data minimization, probably it's not very helpful if we are coming to algorithms and training algorithms. So therefore, data minimization is the wrong principle if you would like to succeed in the digital developments for one purpose, or the deletion can also mean throwing away resources, what you can use for other purposes. So therefore, it would have been necessary probably to get a better balance between data protection on the one hand side, and on the other hand side, innovation, and having data around for to innovate and to train, etc. And this could have been done. Probably there are now other tools what you can think about, but this could have been done via pseudonymization data. So this means for me a little bit a kind of a third category, and would mean, yes, you will protect the personal data of our citizens, and secondly, you may use them in a different way for developing your digital developments. So that's why I think we are sticking too much to this old principle, or not interpreting these in a more modern way. And also what you have already mentioned was also already the rulings done by the ECJ, the European Court of Justice. So this is, if you're looking to Article 8 of the European Charter of Fundamental Rights, where data protection is integrated. So this, I would say, is already a kind of an old approach to these from what we have seen from the last century. But now in these days, you have to interpret these differently. And therefore, probably we are not coming really forward if we have these old principles, and then the court, the Constitutional Court or the European Court of Justice, taking these principles from the past and interpreting everything. And so the adequacy decision and the ruling, like the Schrems II case now, I would say this is in a way also a kind of a political ruling, and with this claim for global dominance of data protection, and this is not the right approach to it. So we should do more kind of a balance of this data protection and national security issue. We should also, if we are coming to the pandemic situation, and these warning apps around, so we haven't balanced the effective management of a pandemic situation to data protection so far in a proper way. And even if we are thinking in the European common market, this is a general data protection regulation, so it doesn't mean full harmonization till the very end, but I think we could have done this also better in not having such a lot of opening clauses here. So that's why we also need to adapt now in the future new technologies, and the interpretation and additions probably, so for the informed consent or whatever it is, we should improve these also. So you see there is a lot of space for maneuver for the future, but at the end, so of course this is the heart or the centerpiece of our digital upcoming regulations. We are orientating on them, but I still would suggest we need also to be a little bit more modern and adapting a lot of articles and improving these, and so that we can't have an interpretation very differently in our member states. And this would be the best way of coming forward.
Perfect. Thank you, Axel Voss, for such excellent initial inputs. Very, very interesting, the perspectives so far. So now, to bring the Latin American perspective, I would like to pass the word to Cláudio Lucena. Cláudio, I would like to know initially, how do you perceive the influence of the GDPR in the Latin American region? And especially for Brazil, we know that Brazil is structuring right now some facets of the bill. The bill was sanctioned a couple of years ago, but it just got into force very, very recently, and with some idiosyncrasies, such as the lack of independency of the national authority for data protection. So I would like you to address this, how GDPR is striking Latin American regulations, and how do you perceive the data governance in Brazil so far?
Thank you very much, Eduardo. Thanks a lot for putting up this panel. I'd like to thank particularly you, Sebastian, and Thomas for bringing up this issue as a starter for IGF. This is a very good way to start it. Thanks for the effort of putting this together and on your. I would like to thank Cus on your behalf for that. Thanks a lot also for the company of Axel, Natalie, and Fiona. It's a pleasure to start this journey here in the IGF with you. Brazil is in the game as arriving as a late player. So we have a lot of space and room and opportunities to make the same mistakes Axel was just referring to. In fact, Latin America looks very much at GDPR as a golden standard, as you might know. Brazil is even a late player in the region. Argentina and Uruguay, for example, are reaching their 2 decades of data protection systematic regulatory frameworks, whereas Brazil is just, well, this year was a particularly rich in development, and particularly the past 2 months have been very intense in Brazil. I'll give you a quick context. We did not have, up until now, a systematic national framework for data protection. We had regulated sectors, such as banking, for example, and but not a systematic framework. As we did now with our data protection national framework, which was not enforced and was being postponed for the past 2 years. And now unexpectedly on September 18th, in the end of August, there was a last vote by the National Congress, which set it to be enforced by the president at some point in September. When that happened, at that point, we did not have the national authority, the National Data Protection Authority, which was created, at least structured, in late August.
Cláudio, this is called a dramatic pause. Let's see. Cláudio, can you hear us? Cláudio? Yeah, I think he's trying to reconnect. Let's just wait a minute. Okay, let's just wait for him to come back. Technical issues. Okay, yeah, let's wait for him to come back, but maybe addressing some other questions. Natalie, you were mentioning previously the influence of the GDPR in the region. And after those initial statements, I want to get back now. I'm talking a little bit more about enforcement and implementation. We already had an interesting overview about a variety of regions, but we didn't tackle very much the enforcement so far. If some countries do not have like adequacy decisions, we still have some room to permit international data flows. For instance, we have binding corporate rules, we have standard contractual clauses. So how do you perceive the possibility of international data flow concerning those other formats in the Asian region?
Do you mean, are you talking about specific sectors or generally?
Generally, but as you wish.
Yeah, thanks Eduardo for the question. Oh, Claudio is back.
Claudio, I think you have to move your camera. But it's different though, this is creativity as well.
Yeah. Do you want me to address the question?
Please, okay. Yes.
Yeah, sure. I think this is therein lies the challenge, right? I think in Asia we have quite a number of multinational companies that are dealing with different sovereign regions. The issue really is where I guess to what extent different countries actually implement or enforce their rules about data localization. Some of them have very specific clauses and restrictions about that. For many other countries, it's a lot more open, like Singapore is quite open. Yeah, I think the issue is really in terms of the extent of to which they enforce this regulations if they are pronounced. So I do know that, for instance, in India, the Personal Data Protection Bill is currently being debated. There are actually existing provisions for data protection, but it is not a singular bill to look at the issue of personal data. But with this draft bill, which is currently being debated right now, then we will have to see to what extent it can be very well implemented. It is still undergoing a lot of debates and so on. So earlier I mentioned also I guess the influence of GDPR. So even as I speak right now, there's a second reading of amendments to the Data Protection Act in Singapore as well, where there are specific new amendments that are introduced that's guided by the consent, informed consent values.
Perfect. Thank you very much, Natalie. Fiona, do you want to jump in this implementation question?
Yeah, sure. Just to point out, you know, the experience here in the US, and I think just to offer that approaches are different, right, based on culture and all sorts of other things. But here in the US, the approach typically is really to figure out exactly very specifically what the rules are going to be through legislation, give the assignment to a regulator. The regulator will then go through a series of public comment processes with the public so that the rules are clear to those being regulated, and then actually go to enforce, because enforcements come with fines and things like that. And you know, the FTC here probably one of the largest enforcers of privacy rules, not just in the US, but around the world. The approach in Europe has been a little bit different, right? It's legislation of principles. And GDPR went into force, I think it was May 25th, and the European Data Protection Board, which is going to enforce GDPR, wasn't even created until the following day. So the approach is very different. It's much more of a, we're going to legislate our principles, they're going to go into a force, we're going to create the enforcement process and work things out as we go. And I only raise this because when I was still in the US government, this was very challenging for the US government and also for government agencies that were having questions and concerns about data flows between government sharing of data, let alone commercial sharing of data. And it just speaks to sort of the different philosophies of how the countries or the regions work. And I do remember some of my colleagues in Europe suggesting to us that we were just a little bit too litigious here in the United States, and we wanted to have things very clear and very specific. And it's just a sort of a cultural philosophy in how things work. So again, here in the United States, you tend to pass broad legislation, give the job to developing the specific rules to the implementing agency. They would go through a series of public comments, then you would go into force. And the approach in Europe has been different, and just to point that out.
Excellent, thank you very much. We have Cláudio back here in our session. Yeah, technical issues happen worldwide, right? So Cláudio, please, I want to pass the words for you to.
Sorry, Eduardo, for the
no problem at all.
By the way, 3:49 in Brazil, I would hardly have support right now. Technical support is out of the question. Just to complete very quickly the briefing I was making to you. On September 18th, we have our bill enacted in Brazil. It's partially enforced since administrative sanctions are only for next year. And the regulator has started to be construed as of now. We have 5 appointed people for the national authority. That's the board of directors. They have already been heard by the Senate, and they're to be appointed at any time and come into office at any time by the President of the Republic. Our national authority, as Eduardo said, as a Brazilian, is dependent on the presidency of the Republic. There is a limited degree of an autonomy. It's not an issue per se, but it's a possible threat, and it's something Brazil will have to go on a stress test when put forward to the recognition that there's independence of this data protection authority, because there is in the text of the regulation. There is an independent autonomy, financial autonomy, and technical autonomy for the DPA, but not the degree of autonomy that one would expect in a global environment. We're talking about a global framework for data governance, it is not the same degree of independence that we see in other well-established data protection authorities. Apart from that, the composition of the board of this first board has also been an issue in Brazil. We have had three out of the 5 directors come from the military. So we know that when we're talking data protection, apart from the other issues that you already mentioned here, there is a slight balance to strike between data protection in private or civil or corporate issues, public institutions, a little bit of security, information security, cyber security, and maybe some cyber defense in the background. The right balance between that is not easy to achieve. We tend to have a lot of cybersecurity and a lot of cyber defense discussions within this board. We do not know how that's going to play. Again, the appointment of these directors is not an issue per se, but they evidently come with a high and a very strong background concerning military. Apart from that, just to wrap up this comments, Eduardo, some interesting controversies already starting to come into play in Brazil, as the authority is not there and the implementation has already started. This is also an interesting interplay in Brazil. Some controversies are starting to have to be solved without the guidelines of the authority. Last week, for example, some courts started to appoint as data processors their employees and even some trainees. I mean, appointing data processors from within the structure without the institutional view. We spent 10 days over that discussion. We had European experts come and help us implement this because this was particularly unsettling, because this was an interpretation coming from courts and they have jurisdiction. If that interpretation consolidates, we're going to have serious problems in incorporating this framework that we're just building now in Brazil in a global framework of data governance, which does not embrace this interpretation at all. So we're starting to have interesting debates and discussions here in Brazil, and I hope we integrate because that's what we're also searching for, right? This integration in a wider global arena where data, as Axel mentions, where data is used as an asset for improvement and for social development with the safeguards that we need to protect the citizen also.
Perfect. Thank you so much, Cláudio. And thanks everyone for keeping up the time. It makes moderators really, really happy. So we are perfectly on track so far in our session. So thank you very much for that. Let me try to explore a bit more the question of enforcement, bringing back the word to Axel Voss. Axel, I would like for you to address a little bit more both the national and the international level on what sense. Even inside Europe, we have different levels of enforcement when we compare the implementation of the GDPR in Germany, Spain, UK, for example. It's a totally different enforcement level when we compare to Portugal, for example. And it can depend on a variety of factors, right? The economical resources for the National Data Protection Authority, as Fiona was addressing as well, a matter of culture, if you want. For example, here in Germany, where I'm based right now, we have privacy bills since the 70s, right? So it's also a matter of culture when we're dealing about enforcement of data protection. And between the countries, we also have different sanctions, and sometimes for the same case, totally different levels of sanction. This is the national level, how you are perceiving the enforcement. And I know this is one thing that the European Commission also addressed in this 2 years anniversary of the GDPR, the necessity of to make a harmonization of the sanctions and enforcement. But how do you perceive this challenge so far? And on the international level, do you think, considering the challenge of international data flow, data transfer, do you think that a global framework for data protection would be a good way to go, or do we perceive differently in that? And we are having this very interesting session here on the IGF, which is one of the most important forums of internet regulation or digital issues. And so my question would be, what will be the most interesting forums, in your opinion, to discuss that, to discuss the possibility of global frameworks for privacy and data protection, please?
Thanks, and thanks for your question. So I hope I can also meet the time frame.
Please take your time. We're perfectly on track. So I know
wonderful.
There were complex questions as well. Please take your time.
So at first, of course, but this might be kind of a challenge all the time for the European single market, in a way that we are saying, so every member state, it's doing its own structures and so on, but everyone has to have a totally independent data protection administration in place, with resources, with know-how, and setting up the procedures, etc., etc. So, of course, in Germany, especially if we are meeting here the federal structure, it's getting a little bit more complicated, because with these 16 Bundesländer, they have to do this on their own, and then they will be presented by someone in the European Data Protection Board, where everyone from the national data protection administration representative will also be a part of it, and they have to solve these cross-border differences. If they have a different interpretation, if they have a different approach on cases, especially this is the case if it's coming to Facebook, for instance. So the Irish Data Protection Administration or representative is handling this differently, like in Germany. So that's why they need to solve it. They need to have interpretation on board. They need to create some safeguards and some structures for specific problems. And they are doing so far, I would say, quite okay. And probably sometimes I'm missing a little bit kind of a more service orientation of the data protection administrations, that they are not saying, no, this can't be done in a way like you're doing this. And then I'm expecting more and more kind of a solution and service they can offer also in solving problems, what companies might have, or also what the member states between each other might have. But they are, so the European Protection Board can therefore in this regard also create binding decisions. We can argue about the legitimacy of these binding decisions by a non-legitimate body in a way, but this is more than less theoretically done. But so far they can do this in a way. And what I would say is, so far I would more prefer if they would have a kind of a counterbody in place who is dealing with the practical issues of digitalization. So only focusing on data protection might not be the right approach all the time. But of course, it should be clear that data protection, of course, should take place, but you can do this sometimes in different ways, and therefore you might get also other solutions and more practical solutions probably sometimes, if you have also someone there who is dealing with these and saying, oh, this is a no-go, etc., etc. So regarding the international community, I would say we can get out of the GDPR already a lot. It's a question of transparency. You will find these proceedings of data breaches and how you can do this. You have all the rights for the individuals. So the information right, or the so-called right to be forgotten. So this is a normal deletion right at the end. the right to rectification of your data, the right to object. Then we have some other issues in place, the data portability, or also, and this can be done also on an international level, the question of privacy by default or encryption. Encryption might also be a way forward. We haven't mentioned this in the GDPR in a way that you can be you can't be satisfied with, but so you can focus more on these points. But at the end, it should be very clear. So we have for all our traffic, and I mean by vehicles and cars, the traffic, we have global traffic signs in place. And here for this global issue of data flowing around the world, probably we should also have something similar here, like common traffic signs for data and data protection. And but the question is, because the interests are so far very differently, in what frame you can do this. And of course, at first, I would say the OECD might be a place to handle these, to negotiate, because all the more than less Western and democracies and rule of law countries are somehow gathered there. So probably not everyone, but you can open these members also for others and negotiation, but also then, of course, the United Nations or the IGF in this regard might be a good place, but then you have also the member states or countries on board who might not be so value-orientated like the Western and democratic countries are. So therefore, I would still think we need to come forward also on this level of more Western-orientated countries. And then, of course, probably as a second step, you might then go with a common position to these on this global institutional level. And so I would say we can get out of the GDPR already a lot for the data traffic signs in a way, and you can handle this also on some of these already existing international organizations, or you are creating a new body. It depends a little bit how diplomatic you would like to be, but there are possibilities, and I would still say it's already necessary to do so. And this would be a kind of a challenge for all the political leaders around the world in sitting together and saying, oh yes, let's do something like this.
Sure. Thank you so much for excellent input. So now I want to get back to Fiona and Cláudio. We have 10 minutes to finalize our session. We already talked about specific data frameworks in different regions, in different countries. We talked about the challenge for international data flow. We talked about different levels of enforcement. And now considering the inputs from Axel Voss, Fiona and Cláudio, let's begin with Fiona, for instance. I want you to address the importance of the multi-stakeholder approach. How do you perceive it as being a key to this enforcement or to debate that we are having around data protection? And also, how do you perceive the challenge of different cultures to really fulfill the compliance of data protection in your regions?
Thank you very much, Eduardo. So I think on the multi-stakeholder question, there's two potential elements. First, there's having conversations like this, right, at the IGF, the sort of premier multi-stakeholder group in the world, where you can actually talk about the issues and understand what other people are thinking and what's happening. without sort of the pressure of having a big negotiation at the outset. I will say, to respond to what Axel had said, you know, in the United States, and I think in Europe and in a lot of OECD countries, a lot of our privacy systems are based on what we've already done in the OECD and the fair information principles that come from that. And the implementation of that has still left us where we are, which is a little bit far apart in terms of how to come together. So it seems to me that more dialogue is probably needed, and conversations like this is helpful. Probably more conversations like this if we're going to find a collective path forward. In terms of implementation of privacy laws, though, you know, in the Obama administration, there was the proposal, as I described at the outset, to kind of have a broad Bill of Rights, and then implementation of those Bill of Rights through U.S. domestic multi-stakeholder processes that could have included people from other countries. That approach did not gain traction in 2012. I don't know if that element will come back next year when there's debates again about the approach the United States should take. But, you know, we did try to actually deploy the multi-stakeholder model domestically to kind of flesh out and implement privacy codes and potentially build, you know, binding corporate rules. So who knows? I would argue maybe that could come back because it's flexible, it's adaptable, things could be changed. You could do with very narrow things, but what we'll see. In terms of the cultural element, I was just pointing it out in the context of, you know, every country is different. Every country has a different history. Every country has a different cultural legacy, and that impacts obviously the philosophy and the approach that you take. And I think it's important to actually understand that and acknowledge it, because often I think we sort of talk past each other because we don't actually appreciate what's driving and what's, even if we're trying to get to the same goal, our approach of getting there could be different, very much dependent on the culture in which our systems and our rules are developed.
Perfect. Thank you so much. So, Cláudio, if you can tackle these issues.
Thanks a lot, Eduardo. This allows me to speak of a very interesting feature of the Brazilian scenario in internet governance. I think this has been in the global arena as a very beneficial aspect of Brazilian internet governance framework. We've also always had a very rich scenario of collaboration and participation that has reflected a lot. I think it is a nice model. It is, once again, it's another interesting structure in our experience in data protection. A multi-stakeholder council is present in the infrastructure of Brazilian data protection. It's not only the authority, there is a council that has a consulting functions, but it is there in the framework. So we can maybe repeat the experience that we have there. Concerning this more concrete and practical issues, I think spaces like the IGF are always a very good place for us to elaborate, and as a laboratory to try to find a solution Axel was referring to. As he was designing in the thought, I think that data protection, and this is an issue here in Brazil, I don't see data protection as an end, as an objective, or as a point of arrival. It's much more means. It's a way through. It means if we're thinking about digital transformation in a wider and global and more universal perspective, data protection is one very important, but one enabler of that way. Let me just give you a couple of numbers that I'm collecting to a work that I'm developing to CAS here from Latin America. We have around 18 million companies in Brazil, out of which 10 million are small and medium and small enterprises, who have never thought about data protection, but who has more than ever this year to think about a digital way to exist. In the same study I'm mentioning that Chile had in February this year, Chile had 0.6% of the population developing some kind of remote work. By July, after the pandemic situation, the figure was more than 18% of the population. So of course, data protection is a key element in enabling a sustainable and safe migration into the digital transformation. But that should be the objective. That should be our goal, not to transform data protection in an objective or in an end in itself, but making sure that we have the right environment in which this digital transformation can be pushed forward in a sustainable and open way. The IGF is a good place for us to elaborate as a laboratory. Professor Daniel Soloff speaks a lot about an anatomy of a data protection general framework. I think it's time for us to at least start looking at that in a more global fashion and in a global direction. But the solution, again, and I agree with Axel, it will depend a lot on how much of diplomatic and political effort you want to put on that. But I am glad that we're able to start this IGF with this very important issue on the table. Thank you very much, Eduardo.
Perfect, Cláudio. Thanks so much. So we still have 5 minutes to finalize our session, so we can have maybe a final round of quick reactions to all of it, if you want. So think about the reactions you want to make as final remarks for our already very fruitful session. Just as a provocation, while you think there on your remarks, Cláudio talked about the right environment, and combining this to what Axel talked about, for example, the importance of privacy by design and by default, encryption, anonymity tools. So how do you perceive also those possibilities of privacy by design, encryption, and anonymity also as a way to go? So please be free on your final remarks, just a quick provocation. Natalie, if you want to start.
Okay, sure. Thank you, Eduardo. I just want to respond very quickly to Devesh question in the chat about how, exactly policy arrangements may differ based on the culture. Yeah, this is a really great question. I must say I don't necessarily think of culture as something that's defined always by the boundaries of nation states. I think for me, culture is about people and populations. So for instance, one of the issues that, or one of the point of discussion in from our fieldwork in India around informed consent centers on how meaningful it is given the relatively weak understanding that the public has about what consent means and about data regulations. I think culture is also very much about, to a certain extent, awakening by citizens about what are the issues concerning personal data. So let me give examples. So I think in Singapore, for instance, the way people understand the protection of their privacy, or their privacy, or rather privacy of their personal data, has actually largely been quite transactional. I buy something, of course, I need to share information about myself. When I check in at the lobby, of course, I need to share my national identity, offer my national identity. But all that actually, that dynamic change when there was a major data leak. So yeah, the way citizens understand the issues around privacy and personal data actually is something that is quite central to the idea of informed consent. The other thing that I would say around on the topic of informed consent has to do with, I guess, more vulnerable populations, which is one of the areas of my research. And to what extent they can understand what it means to say yes to sharing my photograph or sharing my data. I think the other, I guess, last point I'd like to make is also this interesting development in China. I forgot to mention earlier, there is a new data law in China that just came out. And I mean, for very much many of the countries in Asia, it has major implications as to how we deal with not just internet governance, right, as possibly something that is splintered, right, between China and America, or US led, but also around how we actually reconcile, or how we deal with the issue of data, right, as we actually have both types of tech firms, right, that are based in China as well as US and Europe as well.
Perfect, thank you very much. So unfortunately, our time is up. We're just in time to finalize our session.
Sorry.
Do anyone want to make like a final remark in 10 seconds? Or you're fine, we already discussed a lot, right? Okay, perfect. So I would like to thank all our speakers for this very, very fruitful session that we just had. I would like to thank our attendees as well, and also Thomas Biringer and Sebastian Weiss on behalf of Konrad Adenauer. Thank you so much for supporting and organizing this panel alongside us. Yeah, thanks everyone for the fruitful session. I hope we can see each other physically at some point. So thank you very much. Thank you for the attendees as well. Bye-bye, guys. Thank you.
Bye-bye. All the best for you all. Bye-bye.
Thank you.
Bye-bye. Thank you. Thanks for joining.
Thanks.
Perfect.
Thank you.
Thanks, everyone.
Thank you.